Hello, everybody. I am George from Ireland, so welcome back to the English Law Channel. So I'm carrying on looking at co-ownership, more specifically about case law on common intention. So this is often about the old interpretation of common intention. So remember, after Jones and Kernot, as well as Dowden and Stack, presumptions can be rebutted if about the party's common intention is shown to be different from that presumption. The important thing here is that the common intention has to be deduced objectively from the situation. So you look at the situation in the round, and then you decide what the parties must have had as their common intention, but even if they didn't consciously have it. So here's the rub. That what do we mean by common intention? So it's very difficult to figure what that is. So Hudson is a case about common intention, and there are 5 divisions in the case law on this one. So there's the narrow form of common intention on constructive trust, and that's in Lloyds Bank PLC and Rossett. So there are 2 kinds of rights in a home which can be acquired on the basis of one, an agreement, an arrangement, or something like that between the parties about some detriment to one party, and that leads to the acquisition of property. And the second one is contributing to the money to buy the property or helping pay the mortgage. So it's dubious whether anything less will suffice in that case. So and this seems to allow no other way of acquiring any sort of property rights through common intention. All right, so here's another method, and that's the balance sheet method, which is you need to look only at cash contributions and there's a resulting trust. Spring, Etten, Defoe, 1992 is a case about that, or Huntingford and Hobbs, 1993. And that's where the claimant's acquisition of property rights in the home is proportionate to the cash contributions to buying the house. So this doesn't look at any non-financial contributions. Okay, then there's a family assets method, which means the court looks at the dealings between the parties, including non-financial contributions such as childcare. So this is in long-standing relationship. In the old days, often the wife didn't have a paying job, was a housewife. Do we have to say homemaker now? I don't know. So paying the bills might count, or sometimes paying the mortgage, and it's just housework. So that might be enough to acquire even up to half the equitable interest in the house. That's Midland Bank and Cook, 1995. So that's completely different from the first 2 approaches. Okay, then there's another approach that's called unconscionability, where the court looks at situations where it might be unconscionable for the claimant to be denied property rights. Jennings and Rice, 2002, is a case in point. Cox and Jones, 2004. And that's what Australia does. England and Wales has tended to drift away from that. So here a claimant caring for an elderly woman for several years for minimal money, did so expecting the house would be left to her, and the person got £200,000 worth. And then the last method is proprietary estoppel, and it's when rights are given when there's been a representation, some sort of promise, some sort of assurance that the claimant would get something, and the claimant relied on this to his or her disadvantage. So this is remedial, as in to remedy some injustice, and the court can give whatever award it considers fair, bearing in mind the situation. And this award could be even the entire freehold. Ray Basham in 1986 being a case in point, or there could be just some pecuniary compensation, Jennings and Rice, or there could be a mixture between some property rights and some money, as per Gillett and Holtz, 2001. So this is not about common intention, and so it wasn't alluded to in Jones and Kernot. But the House of Lords in Thorner and Major, 2009, upheld it. Remember Thorner and Major, the nephew who did lots of unpaid work on his uncle's farm for 20 years, in the expectation that he would get this, and here's money for whatever it is you to run the property. Okay, so there are lots of questions on this. It can be quite problematic. So you have to look at different cases and look at the judgment of Lady Hale and Lord Walker in Jones and Kernot, which is the leading case in this area. So anyway, the various presumptions as per Jones and Kernot about single ownership of the legal title means there's probably single ownership of the equitable interest, but if there's multiple ownership of the legal title, there's multiple ownership of the equitable interest. Bear in mind that presumptions are rebuttable. if the party's common intention can be demonstrated to be something other than that, than the presumption mentioned here and before. Therefore, various approaches could be applicable, and trying to show which approach is the right one, and then you'll get to the right result. Sometimes there's the Lloyds Bank PLC and Rossett test, which is increasingly out of fashion, but it's got the virtue of clarity. Here there has to be a necessary agreement. Does the claimant contributing to the purchase price or installments, is that going to suffice? So supervising construction work or paying some of the bills don't count at all, according to Lloyds Bank and Rossett. Okay, there could be the balance sheet approach. And remember, that's the majority in the House of Lords in Stack and Dowden, and in the Supreme Court in Jones and Kernot said that they're not going to do that one, resulting trusts. Okay, and there could be family assets, a method as used in Midland Bank and Cook. So look at the course of dealing between the two parties and how long they were married for, possibly their relationship, and what the familial expenses, how those were covered, and who raised the children. And the property could be justified. The property could even be 50-50 split. That could be justified. Because there was a married couple and they didn't want the mortgagee to repossess the property. Or you could use the unconscionability claim and say, no, the claimant has been treated immorally, this shan't be allowed to stand. Or you could try proprietary estoppel principles. So common intentions, you could try and find that. Often you can't come to some clear conclusion. You might say, well, we just have to do what's fair in the circumstances. So it's a quinquepartite approach. A common intention has lots of cases, and you won't be able to discuss all of them in looking at a problem question. So sometimes you need to leave out things like balance sheet or maybe unconscionability if you think they're not pertinent in this case. So some people say, well, drop proprietary estoppel because, that's an equitable remedy, and sometimes it's not apposite. Okay, so Jones and Kernot, you want to know that one backwards, and that's going to be mentioned in every case in this one. You could look at different judgments, dissenting judgments in Stack and Dowden. You could try to analyse the flaws, shortcomings in the legal reasoning of Lord Hoffman, and he came up with this ambulatory constructive trust. Lord Neuberger, remember, he gave a dissenting judgment, and he thought that using a resulting trust for the equity of parties in subsequent situations would have been a better way to deal with it. You see how Jones and Kernot was trying to square a circle. Did they get it right? So look at some jurisprudential scholarship on this one. So which type of trust is going to be deployed? Well, Jones and Kernot is all about constructive trust, even though the principles pertaining to the home are different from other types of constructive trust in general law. So an express trust of land would defeat a constructive trust. Look at Pankhania and Chandegra 2012. So you have to assume that proprietary estoppel is still an important construct here about ownership of houses and ownership of all kinds of land, even though it's not cited in Jones and Kernot at all, surprisingly. But anyway, some scholars say there's a difference between whether rights or not are in the home in the first place, and how much of an equitable interest is going to be. So it's unclear which way judges are going to go, and so precisely because the law is so unclear, this is something that people love to examine. That's enough from me. Toodaloo.